Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, everybody. Happy Monday. I was like, wait, you already said happy Monday, but that's because we did a show earlier today, and this is our regularly scheduled program. Shane, nice to see you. Bill made it. Runaway Alliance. Oh, thank you. You guys liked my red dress yesterday so much, I thought I would break out my red shirt. This is Old Faithful, done me very, very well in my life. Used to wear this to all my job interviews. ADHD life. Anyways, I hope that you've been having a great Thanksgiving weekend with your family, your friends, with nobody, your fish. I don't know. Whatever. I hope you've been doing you this weekend, right? I've been doing me. Take that how you may. I don't wear mascara ever, but it feels like I'm wearing mascara, but I'm not. It just hurts my eye. Hi, Christopher Engelby. Beverly, you were at Walmart today. You barely got any snow. You're a little disappointed. F in the chat for my eye. Oh, F for Thanksgiving. F in the chat for my eye too, though. Yes, that, in fact, this message brought to you by Canadians at large. Please be safe in the cold weather, my American friends. I am from the warmest part of Canada where we're in the States, for God's sakes. If you look at where my island is, it dips into America. But you have to be careful. I do know about it, so please treat the weather very carefully. I know that some shit's going down. I didn't watch Ryan Hall-y'all's thing. We know why. F in the chat for the hat. But, yeah. Other than that, I hear something out my window. I hear something out my window. Oh, hi, Nabel. It was a short one earlier. The TPO hearings were pretty lackluster today, I would say. Would be a good word for it. Lackluster. So that's all we had. Hi, Casey Carey. Oh, you're so sweet. You guys are so sweet. Boosting my ego a little bit. I love it. What was I going to say? Oh, yeah, I don't know what they're doing outside. I'm sure you can't hear it, but I can hear it. And then we are going to watch, it's probably a bear. It's not a bear. I downloaded a bunch of court today. I got us a bunch, but we're going to go to Judge Kirkham and see what happens here. Okay? Okay. Okay. Oh, change the fucking scene, Paisley.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2021-981 DM Zachary French versus Elizabeth French. Today is Monday, December 2nd, 2024 at 9:03 a.m.
Good morning to everyone. The court would note the appearance of Mr. Bailey on behalf of the plaintiff. The defendant appearing in pro per. This matter is before the court on the plaintiff's motion to enforce court order, hold defendant in contempt, and for attorney fees. Mr. Bailey.
Thank you, Your Honor. I believe the motion speaks for itself. The defendant was granted sole legal custody by this court just a few months ago, and plaintiff and defendant, Ms. French, has been filling Flonase prescription at her place of employment. She's a licensed pharmacy technician. She's doing so without the permission of the plaintiff and doing so without the permission of the medical professional who originally prescribed the Flonase.
What? She's filling Flonase? And this is a problem now? Hi, Steffi B. Yes, this is a shirt, by the way, guys. I was showing you the end of it. And hi, Erica, thank you. I'm doing pretty good. I'm confused about the Flonase. Is that like got a stimulant in it, like an ephedrine type thing? And is that what I think I have an eyelash in my eye or something. I swear to God, it hurts. I don't know. Whatever. I'm one of the few people that can wear polka dots. Aw. So, yeah, I'm confused about this Flonase thing. A little bit of amphetamine. Okay. Come on now, people. Come on now, people. Alright, well, everybody's face is just like mine.
Additionally, Your Honor, since filing this motion, there's been some recent events where Child Protective Services is now investigating Ms. French regarding the cleanliness of her home. The Ingham County investigator, who was a liaison because this occurred up north, Brett Gates, went to my client's house last week, informed him of this investigation, asked him to look into an emergency motion. And additionally, Mr. French then informed CPS of this motion and the medical and the prescription that's being filled. So now CPS is investigating Ms. French for the cleanliness of her home, as well as the medical treatment of the minor child, Amelia. So our original prayer for relief, Your Honor, was to have the parenting time schedule that's set to be implemented next fall, which is an every other weekend for Ms. French. We wanted that to be implemented today just because of her lack of discretion with this minor child, the medical care without a medical professional's advice or consent, as well as without Mr. French's consent. But now with CPS investigating this matter even further, we believe a suspension of parenting time may be adequate for a couple of weeks until we can get this investigation resolved. As a result of filing this motion, my client incurred $1,360 in attorney fees, and we would request that Ms. French pay that to the plaintiff for having to file this motion to enforce court order. Thank you.
Thank you. Ms. French, how are you able to, and why do you believe that you're able to acquire medical, attention or medicine for the child when you do not have legal custody?
I did not know I was unable to fill my daughter's prescribed prescription. That was not explained to me. These prescriptions are fully legal and were sent in by the provider. And the one that Mr. French seems to think is a false script was sent in twice on 6/24 at 1:03 p.m. and 1:06 p.m. I was not at work at this time. Other people have typed these prescriptions and were filled by other individuals. I picked it up and I provided the Flonase for Mr. French's household and my own, because Mr. French refuses to fill the prescription for our daughter.
Okay. Well, in this particular matter, when you do not have legal custody, you cannot acquire medical treatment for the child, except instances where it would be an emergency situation, such as an accident or something of that nature that occurred when the child was in your care. You cannot acquire routine medical attention or anything of that nature.
So I am unable to pick up her prescriptions.
You're,
Is that-
you're unable to do anything other than emergency medical treatment.
Okay, I do apologize. I was unaware of that.
Okay, because the plaintiff has the sole ability to do that at this point. I'm not going to, in fact, suspend the parenting time at this point. Obviously, we don't know what's going to happen with the CPS investigation. It's not technically, it's not before the court. It's not in a motion, so I don't have it before me in this particular matter. Court at this point is not going to hold the defendant in contempt. She's given an explanation. I don't know the merits of it, other than it seems like that could be reasonable. So I'm not going to find her in contempt without having a hearing or having more information than I have. But a court does find that it's appropriate to assess the attorney fees for these proceedings. As again, she said she wasn't aware of it, but that's her obligation to be.
Well, that's a very unique ruling, isn't it? Because he has found her not in contempt, but yet is going to, I'm going to guess $500. He ain't going to make her pay $1,300. But I'm going to guess that he's going to say $500. If he says the entire fees, I'll be pretty surprised, to be honest with you. I will indeed.
Informed of what's in the judgment as well. So the court will order attorney fees in the amount of $1,360, which shall be paid within 60 days of today's date. Mr. Bailey, you can prepare an order and submit under 7 days.
Thank you, Your Honor. And if we do find out more information from Child Protective Services, would you like us to schedule just a regular motion hearing around this time?
Yes, what you're going to have to do is you'll have to file a motion, and then Ms. French will have an opportunity to respond.
Okay, thank you.
Okay,
Thank
can
you.
I please state that CPS has been in my home and these false allegations have been shown false? There's been no further communication.
Ma'am, that's not before me today, so I'm not considering any of that.
Okay, I just wanted it on the record that that has been proven false.
Okay, and I want it on the record that that's not before me today, so I'm not dealing with that. So you're free to go. Have a good day.
Thank you.
Thank you.
This case is House versus House.
This brick house. Bam! Also, you guys know we don't mute people, we don't block people, but you can block each other and then learn about it up here and then deal with it.
Kathleen?
Yes.
Okay. Calling case 2024-3089 Kathleen House versus Jonathan House. Today is Monday, December 2nd, 2024 at 9:10 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Mr. Bartel on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, payment of bills, and exclusive use. Ms. Podolsky.
Thank you, Your Honor. As we've stated in our motion, the defendant vacated the marital home back on April 27th of 2024. The parties have one minor child together who's 10 years old. And since leaving the home on that date, the defendant practiced very sporadic overnights and parenting time. From April 27th through November 2nd, he had 10 overnights with the minor child. This was not because my client was keeping the minor child from him. He simply was not asking for the minor child. Then he was served with the instant divorce matter on November 6, 2024, and then had 9 overnights after that because he saw the request for sole physical custody of the minor child made by my client. At this time, Your Honor, we're asking the court to issue a temporary order granting my client the sole physical and legal custody of the minor child with parenting time to be determined by the court. We believe a reasonable schedule is appropriate. This is in line with what the parties have been practicing since the defendant vacated the marital home back in April. Also, since that time, he has been contributing to the marital bills. He's been depositing paychecks and funds into the joint account, allowing my client to take care of house payments, utility payments, insurance payments, and the like, and to provide care for the minor child. We're asking the court to order that the parties continue with that status quo so she can continue to make those payments as he did vacate that marital home. He has since found a rental. In fact, it is right next door to where she is living. But we do believe it is important that he continue to maintain the status quo with her financially, as this is what the parties have been doing since separating 6 months ago. We have outlined in our motion.
Shut up, Kelly. Let me say thank you to Christopher Engleby. Thank you, Christopher. You're amazing. I appreciate you so much. Why isn't your comment showing on the screen as such? I've changed the fucking properties and put the new thing there. Apparently, no, I didn't, but now we seem to care. Yay! Woohoo! If anybody wanted to know how my brain works, that is how it works, with a song inside my brain when I have to do something. Thank you so much, Chris, and yay, welcome to Neuro Spice and Sass. I'm drinking a apple juice box because I'm a bit of a child. My after school snack. Oh, I haven't been to school in a long time.
Where the parties are employed, what their income is. We believe child support should be set pursuant to the Michigan Child Support Formula, and we're asking the court to issue this order today.
Okay, thank you. Mr. Bartel, I read your answer and you said that he was exercising 50% of the time. Was that after the November 6th date when he was served or what?
It was around that time, Your Honor, but I would like to back up. There are text messages, and I think it's a bit disingenuous for a plaintiff to suggest that my client had not actually asked for more parenting time. For example, August 24th.
For example, August 24th, Christopher said to me... Actually, I don't recall August 24th. Oh, thank you so much, Chris. You're amazing. You're so sweet. You make me sing. You make me sing terribly. It sounds like somebody's stealing a car in my driveway. But my theory and thoughts on that is fucking have them. If they are.
There was text messages back and forth in which the plaintiff indicated that she would not do anything except for the weekends. My client says that's not acceptable and I want more overnights. So my client originally was not, as we put it forth in our answer, he was trying to, I guess, not rock the boat, so to speak. Your Honor, there is actually a very close, tight-knit bond between the minor child and my client.
Tammy, 6 months. Amazing. Love to see you. Actually, that reminds me, if anybody sees William, I managed to acquire 2 more of the elephant diamond paintings, and I might be willing to sell 2 of them and keep one for myself. And I know William wanted one. So let's remember that for when we see William next. And thank you, Tammy, and thank you, Christopher, of course. And if you're like, why can't I type Christopher's name? Like, he doesn't show up for me. I think sometimes he has a space in front of it. So don't let that stop you from talking to Christopher, because he's a great guy. Love you, Chris.
He, every single day, Your Honor, picks up the minor child from school, and he consistently has him for at least several hours, if not until his bedtime. And, Your Honor, that has been the case since the child has been going to school. The child is almost 11 years old here in about a week. The child had a breakdown within the last couple of weeks because he's fearful that he's not going to have significant contacts with my client.
Well, which of these parents fucking mentioned it? Huh? Which parent, which douchebag brought the minor child who you just pointed out is 11 into the fray? That child should know fucking nothing about this until it's done. Parents can't figure this out. They literally cannot figure it out. Your kids are not your friends. They are not the people that you talk to about your fucking divorce, okay? If you don't have real friends that you have in real life, go make some or call somebody. But you don't get to tell your 11-year-old about stupid shit. Capiche?
My client did not want the minor child being put in the middle of this. All he said was, I'm not going anywhere. I'll be here. And he didn't want to get into the fight in court, at least the portrayal by plaintiff that he does not have significant ties with the minor child. Your Honor, my client now does have roughly about 50-50. We don't deny for a number of months there he did not have as many overnights, and it's not because of his own choosing. It is because of plaintiff, and he didn't want to rock the boat. But let's not forget, for the first 10 and a half years plus of the minor child's life, the significant contacts and everything that my client did with and for the defendant. He is significantly involved in the minor child's school. He goes to every school event. He helps them with his homework. He just recently, Your Honor, they went hunting again, and the minor child got his first buck. That is how close of a bond they have. I would suggest they have actually a closer bond than plaintiff does with the minor child. But my client knows and recognizes, despite that, it is in the child's best interest for them to continue on with what has historically been a 50-50, at least a 50-50 arrangement will be in the best interest of the minor child going forward. With regards to the expenses, your client, now that we're in this action, I think things have changed. There is going to be child support that is going to be calculated. That is a change from what is before. Plaintiff does work. She wants to be in the house. She wants the exclusive use of the house. My client does not disagree with that and is fine with that. But she should pay for everything related to the house. My client has his own place that he has to pay for, and they can be responsible for their own respective bills, such as cell phones, etc., which my client had been paying for. So we would ask for there to be joint legal and physical custody in this matter, and for there to be alternating weeks for parenting time. I would also like to note my client's parents have heavily been involved in this matter with the minor child, and I note that because there are many times, even of recent, that plaintiff is asking my client's parents to help out if they both are at work. The plaintiff went back to work approximately 4, 5, 6 weeks after she gave birth to the minor child. My client's parents watched the minor child every single day until the child went to school. Okay. And historically, like I said, since plaintiff works beyond when the pickup at school is, my client has always picked up the child, always. And we wish that for the roughly 50-50 to continue forward. That's in the best interest of the minor child. If anything, this minor child is going to be devastated if plaintiff gets her way. And there is no doubt that the minor child wants to have that significant time with my client, and that should continue forward, notwithstanding the several months that plaintiff wanted control in this matter. And it became very clear what she was doing retrospectively.
Okay, thank you. Ms. Podolsky, any response?
Thank you, Your Honor. If the defendant were concerned about the minor child's devastation, he would not have left 6 months ago and then stopped seeing him on a regular basis. Instead, as counsel stated, he didn't want to rock the boat and he didn't do anything for 6 months. Your Honor, the reason why my client was concerned about weekends and weekdays and continues to be concerned about weekdays is because the defendant works at 5:30 in the morning. On the nights when he has kept the minor child during the week, during these last 3 weeks since being served, the minor child is coming back to her, going to school cranky, moody, snarky, disrespectful to her. And that's a significant concern. That's just going to lead us down a tricky path with school. It can lead towards poor performance in school and this mood continuing in school. So we don't believe that overnights during the week would be appropriate because of that work schedule. And yes, my client does work outside of the home and has gone back to work since the minor child was born 10 and a half years ago. And we're not going to shame her for working outside of the home. The parties did use the defendant's parents as childcare, and she's continued to remain in contact with his parents. She's not divorcing them. These parties are getting divorced. She's maintained a civil relationship with them so they can continue to have a relationship with their grandson. So, Your Honor, we do believe our request is appropriate and is in line with what these parties have been practicing for the last 6 months.
Your Honor, can I just make note?
Hold on a
Oh, I'm
second.
sorry. Let's hear
Ms.
the motion.
Podolsky, do you acknowledge that the defendant has been picking up the child from school and having him each day?
He has, it's not every day. He has picked up
I
the minor
understand.
child. Yes, but yes,
Okay.
he has picked up the minor child after school.
Okay, Mr. Bartel, what else did you want to add?
I just want to briefly respond to a couple things. Number one, with regards to the teacher thing, my client last week actually, we knew this was going to be brought up. He spoke directly with the teacher, and the teacher said there has been no moodiness or change with regards to the minor child. I would suggest 50-50, and the court wants an evidentiary hearing that would be fine to show this lie that now is being peddled by the plaintiff. The child has been fine, but with regards to that, Your Honor, I would also make two notations. My client's parents, if need be, are willing to watch the child for that half hour or so while he goes to work. But the other thing I would note, Your Honor, is, this one other case I had with you about 6 years ago, you're not going to remember it, but I had a case from St. John's where the kids were coming down from St. John's to Penfield, hour 15 minutes each way, and this court didn't have a concern around the same age that they would have to be getting up about 5:30 in the morning. I would just make note of that. Finally, Your Honor, my client has been picking up the child every single day after school. Who else is? Plaintiff is working. That's just not true, Your Honor.
Okay.
And my client has consistently every single day seen the child since he's left the marital home. And
Okay. I don't need anything else, Mr. Bartel. Obviously, your memory is much better than mine from a case that's long ago. So I have not much recollection. In this case, however, the court does note, as acknowledged by the plaintiff, that the defendant has been picking up the child after school, having him in the evening. So it does appear that both of the parties are heavily involved with the child, notwithstanding a period of months where, after the separation, where he maybe didn't have the child on an overnight basis. The court does believe that, based upon what's been presented at this point, that there is an established custodial environment with both parties. So what the court is going to do is grant to the parties joint legal and joint physical custody. The parenting time shall be in alternating weeks, commencing at 6:00 p.m. on Friday and then proceeding to the next Friday, with each of the parties having a midweek on the week that the other party has the child. The court would set support pursuant to the support guidelines, order that the parties would exchange all income information within 7 days of today's date so that we can have a calculation of the support. The court would grant to the plaintiff exclusive use of the home and make her responsible for all the expenses, mortgage, taxes, insurance on the home while she's in possession of that. That will be the order. Ms. Podolsky, you can prepare that and submit it under a 7-day notice.
Thank you.
Okay, thank you all. You're free to go. Have a good day.
All right, thank you. You too.
Apparently I have tiny hands.
Kelly, if you want to stay on, I'm going to
Ma'am,
call on
your
one of
voice-
your cases.
Okay.
Her voice is so, it's like a cheese
It's
grater.
Aldering versus Smith.
Okay, thank you.
Plaintiff and defendant are both present. Mary, can you hear me?
Yeah,
Steven,
bitch, we
can
all
you hear me?
you.
Yep.
All right, can you hear me, Mary? Mary, can you hear me? Can you hear me? Can you hear me, Mary?
Ms. Halderlink, are you able to hear us?
Please unmute. Can you hear me?
Yes, I can hear you now.
Okay.
Calling case 2024-2849 DC, Mary Aldering versus Stephen Smith. Today is Monday, December 2nd, 2024 at 9:24 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff. This matter is before the court on the plaintiff's motion regarding parenting time and supervision. The court notes that this matter was originally set last week on November 25th, 2024, and adjourned 1 week at the request of the defendant. Again, the matter before the court is a motion regarding parenting time supervision. Ms. Podolsky, you can proceed.
Thank you, Your Honor. We were actually initially back in court several weeks ago. The court made a ruling regarding custody, parenting time, support, and supervision. In that ruling, the court ordered that defendant's mother would provide supervision for defendant's parenting time. That was something she was initially willing to do. However, as we've stated in our motion, that is not something that she is comfortable doing any longer. As she's outlined in the motion, or we've outlined, and she has attested to in her affidavit, the defendant has told her no less than 2 times that if he is there with her and the minor child, he is going to take the minor child. She believes him when he makes these statements. He's been very reassuring to her that this is something that will happen. His behavior has been erratic and volatile, and she's afraid that she simply would not be able to stop that situation if that were to happen. So we're asking the court to amend the order as it relates to supervision, that the supervision occur at Family and Children's Services at an expense of the defendant. We do believe that this is in the minor child's best interest. As we had previously stated, this just defendant's behavior has been significantly erratic. This is, we do believe, in part due to his drug use, as the court heard about when we were first here in court, his use of methamphetamines. So we do believe that this minor child's safety is at risk, that the supervision component needs to be modified, and we're asking the court to issue an order in that regard.
Okay, thank you. Mr. Smith, what's your response? Mr. Smith?
When we had our thing on the 28th of October, it entered into a judgment that parenting time be supervised by my mother. When I described that to my mother, she had said that she was never aware that that was going to be followed through with. She had been notified that that may be a thing for the future. And then she was describing to me that she was a little bit upset that she didn't get any reassurance that that was going to be carried out. I was the one that gave her the information after the court date on the 28th. In regards to the drug use, everybody at the plaintiff's current address knows that that's not true. So does my mother. And it's already been declared that At 42 years of age, and not once prior have I needed to have supervision to see my children. It's been awarded to the plaintiff in this matter. The only other thing that I can say is the fact that in regards to what my mother claims with her affidavit, I did tell her that it was a foolish idea for me to be supervised by her. And I did tell her 2 times in a text message, which I have here, that it was a foolish idea for me to have her supervised before there was a judgment. And if I got a hold of my son, I had no intention of returning him, because that's the exact same way that he was taken from me. In this case, now they're pushing for psychological evaluation. I have those from the plaintiff's counselor that she regularly sees. Several packets of paper. I've got journal entries over here that declare that nothing for her to fear would come from me. And beyond that, we have consent.
Oh, consent is sort of a buzzword these days, Wahoo. Thanks for being here. Also, did he say journal entries? Like, is he entering his own journal? That's a TV move. A somewhat like crime TV documentary move where it's a big case, but we don't often hear of journals being entered into evidence in most of the cases that we listen to. And I would hazard a guess that most of us listen to more court than the average American or Canadian. But do you know what I'm saying? Like, what other courts are there? Not that many that we're not watching. Anyways. Erica almost has a KCC baby. Oh, I love babies so much. And I love you, Erica. Thanks for being such a supportive member of our community.
For a 24-hour break period, the day that she left, August 14th, when the consent was not.
The consent was not what? I have given my consent to NPC. And also my thanks. Thank you, NPC, so much. From the bottom of my heart to yours. I love that. Appreciate you so much. This guy's version of consent and ours is a little different, I think. Thank you. I don't need to explain to you guys that we laugh when most people are freaking out. Like, this dude's freaking the fuck out right now. And we're just joking around, singing a song.
When it was deviated from that consent, we should have had something that consent is consent, and consent is the law.
Okay. Anything else, sir?
I would like to say that according to the Bible, I only need to declare 2 times that for anyone that tries to create division amongst us. So this is the 2nd time. And I pray for mercy on everybody's soul.
Okay.
Because I'm done.
Thank you, sir. Well, in this case, the defendant has acknowledged that he did say it was his intent to not return the child. He just stated that. And as a result,
prior to his judgment, prior to the judgment.
Okay, that's a concern in this matter. There is an order from the hearing on from October 28th, 2024, ordering supervised parenting time. And the court is not going to change that order. And it does appear that the defendant's mother is not able to or unwilling to or just not able to at this particular point. So the court will grant the request to have the parenting time supervised by Family Children Services. And I say initially, at this time, the court will do so for approximately 3 months. And at that time, the defendant can petition to have that modified, provided everything is going well with the parenting time. And then at that time, we'd have to potentially look at a supervisor. But if we get a report from Family Children Services, then that may change as well. So that's all I'm going to order at this time. Ms. Podolsky, you can prepare that order and submit under 7-day notice of entry.
Thank you.
Thank you. You're free to go. Have a good day.
Thank you.
Wow.
Is Mackey versus Dukes. I do have Kyrie Dukes. I do not have Brittany Mackey in my waiting room.
Did the court receive an answer in this matter?
We did not that I'm aware of.
Okay.
Calling case 2019-1536 DM Brittany Mackey versus Kyrie Dukes. Today is Monday, December 2nd, 2024 at 9:32 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. The plaintiff has not appeared. It is now 9:32 a.m. and the matter was set for 9 o'clock a.m. The court has not received an answer either. This matter is before the court on the defendant's motion to modify custody, parenting time, and support. Ms. Podolsky, the court cannot modify custody without an evidentiary hearing, although the court does find, based upon the pleadings, sufficient proper cause or change in circumstances to meet the Vadvarka threshold for an evidentiary hearing. So the court will, again, have to schedule that. We'll be in touch with your office, Ms. Podolsky. Until the evidentiary hearing occurs, the court will order that the plaintiff's parenting time would be supervised by her parents, and that a court will also order that the children would have no contact whatsoever with Alan Mitchell in this matter. And the court would, at this point, would suspend the defendant's support pending that evidentiary hearing. So you can do that as well.
Thank you.
Have it back to the date of the notice of the motion.
Thank you.
Anything else, Ms. Podolsky?
Nothing for today's purposes. Thank you.
Thank you. You're free to go. Have a good day.
Thank you.
Next case is Conley versus Couch. I do have Attorney Kelly and Zachary Conley present. I do not have defendant Athena Couch. Calling case 2024-1372 DC Zachary Conley versus Athena Couch. Today is Monday, December 2nd, 2024 at 9:34 a.m.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff, who is also present at this matter. The defendant is not present. She is in pro per, and this matter was scheduled for 9 o'clock a.m. It is now 9:34 a.m. As a result, the court will enter the motion before the court is for entry of the final orders. The court will enter those final orders. That will complete the case. So you're free to go, and best of luck to everybody.
Your Honor, two minor things. On page 2 of the judgment under paragraph B, during the week when it's his weekend, parenting time was Wednesday. I have it in there Wednesday 4 to 6. I believe it was supposed to be 4 to 8. If the court could make that small correction, and then that should be it.
Okay, we will. I'll try to catch that and correct it.
This is the diaper fetish case, wasn't it? I'm pretty positive it was. I wouldn't be surprised if she skipped, allegedly, out of town.
Okay, that's on page 2, paragraph B.
The only thing would be is if, obviously, if I'm not able to, based upon the way it's formatted, that would be the only problem.
Okay, if you could let me know, I'll be happy to help out in any way I can.
We will.
Thank you, Your Honor.
Okay, thank you. Have a good day.
You too.
Next case is Gibson versus Lane. I have Attorney Dotson and Attorney Langenberg. Please. Calling case 2015-1454 DP, Ebony Gibson versus Richard Lane. Today is Monday, December 2nd, 2024 at 9:36 a.m.
Court will note the appearance of Mr. Dotson on behalf of the plaintiff, Ms. Langenberg on behalf of the defendant. The matter is before the court on the motion by Ms. Langenberg to withdraw from this case. Mr. Dotson, do you have any, I don't assume you have any opposition to that?
No objections, Your Honor.
Okay. As a result, the court will enter the, Ms. Langenberg, I don't know, did you include an order with this or do you have to submit an order?
There should be an order attached to the motion, Your Honor, as an exhibit to it. There
I'll
should
look
be an
for
order
that.
there.
Reason we have to look for it when the clerk gets those, they don't send them in separately. They don't forward them sometimes. So we'll have to pull the order up and get it signed.
If you don't have it, we can always remail it in or something to that effect, or email it if the court needs it.
We'll
But it
check.
should be there.
If it's attached, we'll be able to get it. We know it's there.
Okay,
Okay. Thank you both. You're free to go. Have a good day.
thank you, Your Honor.
All right, let me find one more that'll finish off our evening. I guess that's it.
Yeah, sorry, I had to switch headsets. I could barely hear you.
Me too, bro.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2024-2979 DM, David Carney versus Shauna Carney. Today is Monday, December 2nd, 2024 at 10:02 a.m.
Good morning to everyone. Court will note the appearance of Ms. Moss on behalf of the defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time, and support. Ms. Moss.
Thank you, Your Honor. Good morning. We are asking for sole physical and legal custody to be with my client. She's had the established custodial environment since the parties separated in March, and she was the primary caregiver even before that separation. In the beginning of August, plaintiff is charged with assault with a dangerous weapon and domestic violence against my client. And associated with that criminal case, there is a PA 53. Also at the beginning of August, he threatened to take my client and her two children, ages 7 and 3, to their mobile home and burn it down. I must note that he has previous convictions for arson, so this felt like a very credible threat. There's a history of domestic violence and abuse between the parties. Between that and the established EC with my client, we feel that sole legal and sole physical custody to my client's appropriate. However, my client is very willing to facilitate parenting time as long as it is supervised. She proposes plaintiff's mother, Stephanie Smith, be the supervisor. She proposes Saturdays, noon to 6, when she believes both the supervisor and plaintiff are available. We're also requesting that transportation be handled by a third party, given how volatile things are between the parties, and that plaintiff be responsible for arranging that transportation. We're also asking for child support to be calculated by the guidelines, and we are willing to use what plaintiff said in his response to our motion of $23 an hour and 45 hours a week for his income.
Okay, thank you. Mr. Carney, what's your response?
Your Honor, I am not a danger to my kids or Shauna. I just had my children the whole entire weekend, Saturday through this morning. That was perfectly fine and acceptable. We communicate through third party. I did not leave the trailer until I want to say the end of June. But while she was at work, I was watching the kids. I went and got an over the road job and I quit it the same day because I didn't want to have my children put in daycare until she got out of work. And then when I got that job, she took the kids away from me. And I have not threatened my kids or her in that regard. But when I got that job, she took the kids from me. I tried to pick them up from school one day and she called the police on me. CPS got involved for a welfare check. And so lately haven't been able to see my kids like that, only when she's in a good mood or when it's convenient for her. Like, and I've only been willing to, when she goes to work, like I'll have third party transportation pick up the children so we have a babysitter because we don't need that expense. Because I'm fully capable of being their father. As part as the case goes, I've replaced her window that I broke on the vehicle, and that I've put myself in Summit Point. I see a counselor. I'm on medication. I'm not suicidal, and I've got notes I can get a note from Summit Point saying that I'm there on my own behalf to make myself better mentally. I just want to be a father, and lately I haven't been able to in the past couple months because the PA 53, and then she's threatened my bond as well if I don't return the kids. If I pick them up from school and I don't return them on her time, then she'll threaten to call, interrupt my bond and put me in jail. So it's gotten to the point where we need someone to step in, but full legal and sole custody, that shouldn't happen.
Okay. Ms. Moss, is it correct that he had the children this last weekend himself?
It was supervised by his girlfriend, and my client communicated with his girlfriend to guarantee that the girlfriend would be there supervising and would not leave the children alone with him.
Ma'am, sorry for interrupting. There was no communication in that regard. It was just, hey, David can see the kids this weekend. Have them back by 7 a.m. Monday.
Okay. Well, what the court's going to do in this matter does appear that, again, that the established custodial environment since the separation, notwithstanding the contact that the plaintiff has been with the defendant, so the court will, on a temporary basis, grant to her the legal and physical custody of the children, provide for standard parenting time to the plaintiff in this case, and the court would order that the parenting time would, again, be exercised in the presence of either the girlfriend or the paternal grandmother during those particular times. Support would be set pursuant to the guidelines, as Ms. Moss has already stated in this matter. Ms. Moss, is your client working so she has income?
She's working, but she's only working, she gets $10 an hour and 25 hours a week.
Court would impute to her at least that at 40 hours per week for purposes of calculation. And the court would order that the plaintiff would have a third party transport the children for parenting time. Yes, sir.
I just wanted to add, so it has not been since I have left the house in June. Up until I want to say September is when I got the job. She'd go to work. Every time she goes to work, I have the kids overnight. And that was till the beginning of September.
Okay.
So it wasn't, she's established that. It was she was withholding the kids from me in using the PA 53 against me. So
Court notes that you had that in your answer, so I did.
Yeah.
I was aware of that, but
Okay, I just
on a
wanted to.
temporary basis, this is what we're going to do. And being that you had the children this last weekend, your alternating weekends would happen 2 weeks or a week from this next Friday.
So I get them twice a month?
You get them alternating weekends, and then midweek, if the parties can't agree on a day, then it would be a Wednesday from 4 to 8.
I can't with my schedule. That's
You can't
can
do
I,
it.
Your Honor, can I just do something temporary or actually full? Can I give her full legal and physical custody?
She's
And
already got that. I've
yeah,
already
yeah, yeah.
ruled.
But I want to give my rights to her as like I don't want any rights.
Well, you'll have to deal something with that, but that's up to you. And then
Do you know how I would establish that?
I'm not going to give you legal advice. There's ways that you can go about that, but you'll have to do that.
Okay.
You might want to contact Miss Moss and make arrangements with her.
Yes, I would love to do that.
Okay, you can call her and make arrangements. Miss Moss, you can prepare the order, submit under 7 day.
Your Honor, can I just clarify? I want to make sure I understood that we're imputing 40 hours per week at $10 per hour?
Yes, yes.
Okay, thank you.
Okay, thank you. Have a good day.
You too.
I'm sort of speechless. He turned on a dime. I don't think the medication's working, bro. You can't give it up by saying it. It's not a magic spell, Erica. Oh, McNiff!
Your client plans on appearing this morning?
She's there. It looks like she just hasn't turned on there she goes.
Oh, okay. I just brought in someone else. I'll check them in real quick. Janelle? Janelle, I'm gonna place you in the waiting room for your 10:30 hearing, okay? Thank you. Mark? Can you hear me?
Yes, I can now.
Okay, is your client with you?
No,
Do you know if he plans on appearing this morning?
I don't believe so. We aren't contesting the entry of the order.
All right. Calling case 2024-2665 DM Ashley Terry versus Richard Terry. Today is Monday, December 2nd, 2024 at 10:12 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Robison, on behalf of the defendant. The matter is before the court on the plaintiff's notice for entry of order in this matter. Mr. Robison, as before we went on, has stated that he's not opposed to that. I wonder, what did you do, Ms. McNiff? Did you beat him down or bribe him though he wouldn't oppose that?
A little of both, Your Honor.
Oh, okay. Well, we will enter the order then, there being no opposition to it.
Thank you, Judge.
Okay, thank you.
Did you beat him or bribe him? Oh, wow. He likes McSniff. She's in the old boys club, it seems. Right? Okay, one more. One more. I said that last time. I'm terrible. I'm terrible. Yes, I am. I'm terrible. Like the lady's voice. It's terrible. It's terrible. It's terrible. It feels like a fucking hot poker inside my brain every time she speaks. Without fail. She's gonna jump scare us here in a minute. If I go fast forward it, it's gonna fuck it up. We're just gonna have to hold through this together, and it'll happen. But seriously, it's like a hot poker when it sort of enters a part of your brain and then it dies. Here we go.
Okay, just a moment, please, here to open the record.
Hey Zeus, thank you, Jesus.
Okay. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, December 2nd, 2024 at 1:25 p.m. For 2024-2979 DM, David Carney versus Sienna Carney. I do not have the plaintiff here.
Ms. Moss, what did you do? You chase the plaintiff away?
I thought I was very nice this morning.
Okay.
I haven't heard from him since the motion hearing this morning.
Okay.
If you wanted to enter a default, I would not object.
Did you file for a counter complaint for divorce?
Yes.
Okay, then we can do the default. I was going to say, well, if you hadn't, I wouldn't be able to go ahead with it. Why don't you do that? File the default, and then you can proceed to prepare your judgment, and UCSO, and all that, and then you've got a lot of time. I mean, this is very early, and then when you notice it up, who knows if he's going to respond at that point.
Okay.
He didn't seem to be happy once he didn't get what he wanted.
Right.
Yeah. Kind of remind me of being home, you know?
That's right.
I'm always upset when I don't get what I want.
Right. We all want what we want.
Yes, that's true. Okay, well, why don't you proceed that way, and we won't do a scheduling order at this time. There's no need at this time, and just get the default in and proceed.
Okay. Thank
Okay?
you.
Thank you.
Have a good
day.
afternoon.
All right, have a good one, Ann. Okay, let's go to the status conference here. Please unmute both of you. Mr. Quant. Okay, there we go.
Did you just call him Mr. Cunt? You can't call him that. What is his name? You cannot call him Mr. Cunt. Is that his name with a Q? Cunt? Oh, that's fucking epic. That's funny. Oh, that's goddamn fucking hilarious. I'm also brought back to trauma by a case from Schaefer. I can't remember what case it was, but I remember The Office.
Thank you for your patience. So this is 2024-3008 CB, Michigan Gas Utilities versus Quality Converters. It's Monday, December 2nd, 2024 at 1:27 p.m. Attorney Quant for the plaintiff and Attorney Schaefer for the defendant.
Okay, good afternoon to both of you.
Hello, Judge.
Mr. Quant, you're muted.
There we go.
Okay.
Thank you, Your Honor.
So enlighten me, what's happening at this point? Where are we at?
Well, I think that Mr. Schaefer and I are going to continue to try to work on a consent judgment that might resolve the matter, but if not, we'll just continue down the normal discovery process. I believe that we've given Mr. Schaefer and his client till the 20th to provide an answer. I think that they may be considering a counterclaim, and then we'll go through, disclosures and discovery as necessary. But I think that Mr. Schaefer's a problem solver, as I've experienced in my short time working with him. And
No, you got that wrong. Mr. Schaefer causes problem. He's a problem causer, not solver.
I guess.
Judge is so cheeky today. He loves December. Oh, it all comes together. I love it too. Look at that smile. Yes, Judge. He is so cheeky. It's epic. I hope it persists the whole month. A month of cheekiness with Judge Kirkham. I'd watch every day. I would watch every fucking day, Judge. I will. I mean, who am I kidding? I'm going to watch every day anyways.
Your reputation precedes you.
Okay. Well, that's good. Anything that you have, Mr. Schaefer?
I would agree that we are making efforts to resolve it. We've resolved some temporary things. I think it can be resolved. I reviewed Your Honor's boilerplate requirements. There's going to be some difficulty time-wise. Are you planning on sending this to ADR? Because I don't think this is necessarily an ADR case.
I'll send it to mediation.
Okay, and we talked about mediation, and we've agreed on a mediator, but his availability is like in May, I think, is what we. So that's going to be problematical in your time frame of your order.
Right, right. Who's going to be the mediator?
Lee Silver out of Grand Rapids.
Okay, okay. Yeah, he does a very good job.
A truck? A Silverado? A truck? Is that something different? This whole case, I don't understand what it's about. I don't understand any part of it, but so much of it is funny to me, and I love that.
On mediation and gets matters resolved pretty well. Why don't we do this? I'll set about 60 days out for an additional status conference, and then we can see where we're at that point.
Okay, good.
If you need anything before that, you need a status conference, just contact my office and we can do it over the phone and get you in relatively quick.
Appreciate that.
Okay, good.
Okay.
Sounds like a plan.
Okay, great. We'll let you go then. You have a good afternoon.
Thank you.
Okay, very good.
All right, thank you. And we're going to close it here. And
One more because I'm feeling feisty. And because I wanted to make Courtney's dreams come true.
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2021-776 DM Chelsea Joswiak versus Ryan Joswiak. Today is Monday, December 2nd, 2024 at 10:31 a.m.
Court will note the appearance of Ms. Henderson on behalf of the defendant. This matter is before the court on the plaintiff's motion to terminate counseling with Ms. Katz. Go ahead, Ms. Joswiak.
On or around September 6th, I received a letter from Ms. Katz stating that she would be retiring November 30th and that the practice would be closed. She even goes on to state that she can help with referrals and your records. So I took that as we would no longer be using her services. And then I was required to have 2 Zoom meetings with Ms. Katz and the defendant. And the second meeting, it ended with Ms. Katz saying that she is backing out of this, that we do not want to work together. She said, you two do not want to try. You don't care enough about your child's best interest. She feels sorry for our children and there's nothing else she can do. She quits. I then asked who she was speaking to, and she said both of us. By the end of the Zoom, it then led to, Ryan, I'll see you on Friday. We have an appointment. So insert the bias treatment that was received several times over this. Also in the letter, I didn't get any information that Ms. Katz would be servicing people separately after retiring, although the defendant's motion claims that the defendant and the children can continue going if they are willing. All parties know the children are not willing. Last I was told, they didn't attend 2 of the sessions. They refused to go into the room. Since then, the defendant and I have both put my son's personal counseling on pause as he does not want to speak. So that would make him unwilling. And my daughter doesn't want to go either. The transition period is now over. The kids are with the defendant for 5 days and with myself for 3 until the 92 days are made up. We no longer require Maridessa Katz services. In this situation, it is only added to toxic behavior and unwanted things between the defendant and myself. Also, I believe that this is retaliation on her side, as Dr. Hogan is under investigation regarding this case, and so is Mayor Dessa for discrimination, unethical practicing, possible dual relationship, and bias counseling. So I would like to terminate this service from her. If you deem that it's necessary, we continue counseling, such as family counseling. I would suggest Margaret Hunter. She's had success with many people in this same situation. Thank you.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. As we stated in our written response, Ms. Katz is willing to continue working on a part-time basis, even though she is retiring from full-time practice, specifically with defendant and the minor children. It is correct that due to the breakdown of the relationship between Ms. Jazwiak and Ms. Katz is no longer willing to work with Ms. Jazwiak, and that's largely due to her belligerent behavior during the sessions. There is a motion that was scheduled for next week in front of Your Honor due to the concerns that were expressed by Ms. Katz regarding Ms. Jazwiak's behavior. So at this point, Your Honor, we would not object to Ms. Katz not working with Ms. Jazwiak anymore. But we're asking that my client be allowed to continue working with Ms. Katz on a part-time basis, as well as minor children if they're willing.
Okay. Well, in this case, court would note that I've had obviously Ms. Katz as well as Ms. Hunter in my court numerous times before, and I've always found both of them to be very professional and objective in the case. Not to say that there hasn't been disputes, as there obviously was in this particular matter when they find that they can't work with a particular party. What happens is court would order that, again, the counseling with the children and the defendant would continue with Ms. Katz if she's willing to do that, and that as it relates to any co-parenting counseling between the parties, that Ms. Katz would make a recommendation as to who could handle that counseling, because clearly it appears that there needs to be some counseling between the parties in this particular matter. Ms. Henderson, the plaintiff has recommended Ms. Hunter for that. Do you have any problem with Ms. Hunter doing the co-parenting counseling?
I do not, Your Honor. I've had Ms. Hunter on several cases. I have no issue with her stepping in.
Okay, why don't we do that? Put that in an order, and we'll have Ms. Hunter, who will provide the co-parenting counseling in this matter, but the parties can, the defendant and the children can continue with Ms. Katz if he desires, or he can move that to Ms. Hunter as well if he wants to. So,
Your Honor, did you still want Ms. Katz to render recommendations?
No, not if you've agreed that Ms. Hunter would do it. So.
No, I have no issues with Ms. Hunter. I've had her on several cases.
Okay. Why don't we do that? I'll ask Ms. Henderson. I know it's not your motion, but I'll ask that you would prepare the order and submit under 7 days, so that gets completed.
Yes, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
Yeah. Sounds like she withheld the kids for 90 days because she had to pay back the 90 days.
Next case is Odell versus Keach. Plaintiff and defendant are both present. Please unmute.
Can you hear me?
Yes.
Yeah.
All right.
Calling case 2016-3590DS Leslie Odell versus Robert Keach. Today is Monday, December 2nd, 2024 at 10:38 a.m.
This matter is before the court on the plaintiff's objection to the referee order. In this matter, Ms. Odell, you can proceed.
I got a letter in the mail from a friend of the court saying that his support order was lowered to $3.75 plus some other charges for arrearage and service fees.
Okay.
Is that correct?
That is what the order says, correct.
Why would it be $3?
I have no idea. The referee doesn't state in the order. The order is just what it is. I will tell you when the court reviewed this, there was an order for child support back in April 5th of 2017 that provided that the support would be $375 per month. Then somehow it got to the $3.75 under the current order. I don't know where the $3.75 came from. I can't find anything in the file as to how that would come. So it was going to be the intent of the court to refer the matter back to the referee to see if that was an error as far as an arrow, decimal point should have been $375 as opposed to $3.75. I just don't know based upon the file. So.
Well, I doubt it was a typo unless they typoed it several times, because it states, as of November 1st, 2024, the respondent shall pay $27.25 monthly, and then it breaks it down into the different categories.
Right. But I don't know if it was just, like I say, an error from the earlier order, or if that's what the intent was of the referee. I don't know.
Okay.
So I'm going to refer it back for an explanation as to where that came from.
Okay.
Okay.
So would we find out on, I think it was December 20th, the meeting was adjourned to?
I don't know. I don't know what's on the referee's schedule. All I know is we'll refer the matter back to the referee, and then he can make an explanation.
Okay.
Okay.
All right. Thank you.
Okay. Thank you. Thank you both. You're free to go. Have a good day.
All right. Thank you.
And I do have Chanel Smith present. Let me check on this rifle. Please unmute.
Okay.
No, you're fine, Chanel.
Okay. Rain dirty.
Morning, can you please unmute?
Oh my God. Woo! NPC, you're amazing. I love it. Thank you so much. If you just became a member, guess what? We did a members only earlier today. A TPO case. You get to go listen to it, watch it, do the thing. Make sure to comment. Let me know that you were there. I read those every morning. When there's none, I cry. Hold on. Did she say something about dirty? Bitch, I'm not dirty. I don't look dirty. Yay, NPC. Thank you so much.
Rain dirty.
Morning, can you please unmute? Your name, please?
James McKinley.
All right. Calling case 2009-205.
Hold on, he's appearing from a multi-story stairwell. The echo is insane. It's not often that we see somebody be able to pan up and then the camera shows like fucking 6 stories. God. And she said the screen dirty. The screen dirty.
40 Chanel Smith versus James McKinley. Today is Monday, December 2nd, 2024 at 10:41 a.m.
Okay, Mr. McKinley, if you could find a place to sit down, it's very disconcerting with the camera moving.
Yes, sir.
This matter is before the court on the plaintiff's motion to set aside referee recommendation. The plaintiff has stated that she makes $25.05 per hour, working between 20 and 25 hours per week. Says that her bring home is obviously $400 to $500, which obviously is net as opposed to gross. So what are you claiming to be the factual or legal error, Ms. Smith?
Well, on the paper that they sent, they said that I made 48,000 a year. I have never made that. I worked at Target for 10 years. I never made that kind of money before. I only made last year 29,000 for the year. And I only made this year so far, it said 32,000 for my gross and 28,000 for my net pay. And I only get 4 more checks. So I don't care that they lowered the child support. That's fine. But I need them to have my gross in there right, because it's making it look like I'm making way more money than what I'm actually making. And on occasions I need help. I might need help with a water bill, a gas bill, and then I'm turning in my paycheck stubs. But I got the court saying that I make this kind of money is messing me up.
Okay. I don't know what, when the referee put the 48, I will tell you what happens is the referee had used for your income though, 500, if you look at the calculation on support, he used $566 per week. And if you divide that by the amount you make per hour, it works out to only 22.59 hours per week. So I don't know where the 48 came in, but it didn't. When you look at what he utilized in the calculation, it only came out to the amount that you're claiming that you make per hour.
Okay. So I make $25.05 an hour, but I don't bring home,
So they don't figure it on your net, that figures it on your gross. So.
Yes, but I don't bring that home.
Okay.
I make good money hourly, but I don't work 40 hours a week.
I understand. I'm just saying the referee, in what he calculated, if you look back at the calculation, he had you making effectively $566 per week, and divide that out by the 2505, comes out to 22.59 hours, which is in between what you claimed the hours you work. You said you work between 20 and 25 hours, and that's about halfway in between.
Okay. So that's right.
So that would be correct. I don't know where the 48 came in.
I just seen it at the end of the calculations. It was saying 48,000 a year, and I bring home 3,500 a month. When I don't bring home 3,500 a month, I bring home about 1,800 a month. Net about 25 gross. And that's what scared me when I seen that it was saying I made that kind of money. I wish I did.
Yeah, no, look back at his calculation and look at the support calculation. It'll show you how much you had as far as your gross amount and the hours. And if you deduct the hourly pay, it'll come out to, again, that 22.59 hours per week. So
okay.
I don't know if it was a misstatement. I don't know what it was, but if you use the calculation, it doesn't calculate it on.
Okay. It just scared me. Okay, I'm sorry. That's all. That's the only reason I filed the motion. I don't care that y'all drop support. I just need some kind of help.
Yep. Okay. Well, otherwise, I think that it's the referee had done it correctly, other than it might have been a misstatement as to the amount. I don't know why.
Okay.
Okay.
All right.
Okay, Mr. McKinley, because the court's affirming that referee order, you don't have anything that you have to do. So I don't assume you had anything to add then.
Yes.
Okay. Thank you. The order will remain, and you're free to go. Have a good day.
I had something to say, Your Honor.
Oh, you did?
Yes.
Okay.
What is the order? I'm the one filed the motion, and I've never received what the order is, because I started working and I'm homeless, and that's what I've been trying to tell Chanel. I need to lower the child support payments.
They did lower it. They took off $200 extra a month.
Well, why no one told me?
Well, sir, I don't know if you've had a change of address. You need to go to you need to go to the front of the court's office and change your address. And if you do, what they probably did is send it to your last known address. If in fact you have a change of address. You can go to the clerk's office and you can get a copy of the order as well. And so I'd suggest that you get a copy of the order. You can review it.
Thank you, Your Honor.
Then you can proceed there. Okay?
Okay, thank you, Your Honor. Have a good day.
Have a good day. Bye.
Bye-bye.
Bye-bye, bye-bye, bye-bye. That's the wrong cadence for that song. Bye-bye, bye-bye, bye. Guys, I think that Creed is live over on We Got a Jackpot. Go ahead and check him out. I know he's even turned Mikey into a bit of a degenerate gambler. So it could happen to any of us and all of us. But honestly, it is a good time. There's lots of familiar faces over there. Good times to be had. You guys are so sweet. You're buttering me up. I'm gonna stuff my face with food. That's as far as I've thought ahead, to be honest. But thank you so much for all of you guys for being here tonight. Thank you for your generosity, and thank you for Courtney, I love it. Thank you for being you. It means a lot. I love our strange and weird little place we got here. Remember, do me a favor. Remember that I love you and I'm proud of you, and I will see you in the next video. Also, remind Creed that I still can't redirect to him. I tried. Let me try one last time before I do this. Won't let me. There it is. It's upcoming, but it won't let me do it. So remind Creed he is yet to fix that problem. Yeah. Love you. Proud of you. See you in the next video. Bye.
Ways down and